Good morning, everybody. My name is Yvonne Ewang. I'm the Associate Legal Officer in the Secretariat of the Basel, Rotterdam, Stockholm Conventions. Thank you all for joining us this morning. It's a great pleasure to have you all with us, and we hope that this webinar will provide you with some useful information on the topic both of the ban amendment and processes or procedures of becoming a party to one or more of the Chemicals and Waste Conventions. So just before we go into the processes and procedures, to give you an overview of where we stand at the moment. As many of you may know, I see many familiar faces and names in the list. We have the oldest of the three conventions, the Basel Convention, which was adopted in 1989, entered into force in 1992, and there are currently 180 parties to that convention. At a later stage in 1998, the Rotterdam Convention was adopted and entered into force in 2004. There are currently 154 parties to Rotterdam, and third in the list, we have the Stockholm Convention with 179 parties. It was adopted in 2001 and entered into force in 2004. So, as many of you, again, may know, all three of these conventions look to protect human health and the environment. There is a significant overlap between the scope and the coverage of all three conventions, which work together to provide a framework for life cycle management of chemicals and wastes. So looking at a cradle-to-grave or cradle-to-cradle approach. Today we'll be looking at the processes and procedures of becoming a party to the convention, but with a specific focus in relation to the amendment to the Basel Convention. We'll look at the similarities in these processes and procedures, and I will also try and highlight for you where there are distinct differences between the requirements of each convention. So firstly, turning to what is the ban amendment. Some of you who are government representatives may also be aware of the ban amendment in terms of your countries have already agreed to be bound by it. It was initially adopted as a decision at the second meeting of the Conference of the Parties to the Basel Convention in March 1994. And the parties agreed to immediately prohibit all transboundary movements of hazardous waste, which were destined for final disposal from OECD to non-OECD states. And in the same decision, they agreed to phase out by the 31st of December 1997 and prohibit, as of that date, all transboundary movements of hazardous waste which were intended for recovery or recycling operations from OECD to non-OECD states. And at the next meeting, which was in 1995, the parties adopted a further decision where this was put into an amendment to the convention. So in terms of the scope of it, the ban amendment provides for the prohibition by each party in a new annex to the convention, Annex 7, which lists the parties and other states who are members of the OECD, the EC, and Liechtenstein. So there's a prohibition by those parties of all transboundary movements to states that are not included in that Annex 7 of hazardous waste that are covered by the convention and intended for final disposal, and of all movements to the states not included in Annex 7 of hazardous waste destined for reuse, recycling, and recovery. Now, the latest decisions on these matters were taken at COPs 10 and 11. COP 10 was held in 2011, and COP 11 was most recently in April-May 2013. There was some difference between the parties after COP2 as to the requirements for entry into force of the ban amendment and interpretation of the provision of the Basel Convention about amendments. There was a decision taken at COP10 whereby the parties agreed, without prejudice to any other multilateral environmental agreement, to an interpretation of the meaning of the provision of the Basel Convention that deals with amendments. I must highlight at this point that it was an omnibus decision that covered what was seen as key issues to the Basel Convention, including the ban amendment. So it covered, for example, issues such as environmentally sound management of waste. It also covered illegal traffic. It covered regional centres. And it covered issues relating to capacity building and legal clarity. The latest decision, adopted in 2013, requested the Secretariat, within available resources, to continue to assist parties on request which are having difficulties in ratifying the ban amendment. So within this context, in response to this request from parties, the webinar is offered to you with this specific focus. What we'll look at is both the requirements that are set out in specific treaties that we're looking at, as well as subsidiary rules that may be contained in the Vienna Convention on the Law of Treaties. So there are general steps which would apply, as well as convention-specific steps. So what would be the procedures for becoming a party, and how would those apply to amendments as well? The essence is that the state concerned must express consent to be bound by the treaty. And you'll see here just a brief screenshot of the treaty handbook, which has been prepared by the treaty section of the Office of Legal Affairs for the United Nations, and is actually a very useful resource that you may wish to access from the United Nations Office of Legal Affairs website page. It's available in all 6 UN languages, and sets out the general steps, as well as the explanation about the depository practice in relation to the conventions. We must stress here that the procedures for expressing consent to be bound do vary from state to state. So a procedure that would apply in one country may not necessarily be entirely applicable in another context. The convention-specific steps first. Each convention specifies how a state can express consent to be bound. A key is that this instrument, whether it be for example, an instrument of ratification, an instrument of accession, they would need to be transmitted to the depository of the convention. And the consent to be bound would only take effect once that instrument has been deposited. The state would then become a party on the 90th day after it deposits its instrument. So the provisions would only become legally binding on that date. Beforehand, however, we've seen that there are some general steps that may apply in several different contexts, and that may assist if a state or a state is considering whether to be bound by a convention or one of the amendments to it. These steps I must highlight. There would be some differences in relation to amendments, but we'll look at those in just a minute. The first step that may wish to be considered is preparing analyses and collect documentation. So looking at what are the benefits and implications of becoming a party and balancing those with the associated costs. There would need to be contact made between the relevant authorities at the national level. So that could be, for example, a communication between a Ministry of Environment and a Ministry of Foreign Affairs. It could be consultations with various different ministries. We know that in some countries there is a wider consultation as well. And that could lead to the state identifying and undertaking whatever processes might be needed to lead to an approval or an endorsement of the ratification, acceptance, approval, or accession process. So essentially, whatever process would be relevant for your national context to show that that state agrees to be bound by the provisions of the relevant convention. And then next, you could look at if any declarations or statements are needed. The instrument that would be prepared and transmitted would need to go through the national process. So that could be, for example, just an executive order. It could be a parliamentary process. You would need to have a consultation with the relevant authorities at the national level to see what would be appropriate there for your context. But there are model instruments that are available to assist in this process, and they are also located in the treaty handbook that we saw just a couple of minutes ago. As the next step, the instrument will need to be deposited with the depository. And just to sum up what those steps would be, you'd have to look at what type of instrument would be needed. Is it a ratification process? Is it an accession process? That would be part of the national level consultations. Who can execute? It's usually a head of state. And again, there is guidance in the treaty handbook as to who can execute the instrument. The form or the format, and here also we would invite you to consult the treaty handbook for the models, which may be of assistance to help develop any other instruments. And then how to deliver that instrument, and whether you would need any declarations, reservations, or exceptions. I must underline here that the instrument does become effective only when it's deposited with the depository. This is a step that does cause a lot of delays on a frequent basis, because we often receive, as the Secretariat, the instruments, which we then transmit by email to the depository as information, but that does not amount to a deposit of the instrument. That would have to be done in accordance with the depository practice by an authorized entity of the state. So just as a visual summary, you see there the steps that could be done before deposit of the instrument: preparing analyses, collecting documents, contacting authorities and having national consultations, identifying and initiating the processes, looking at declarations or statements, and then preparing and signing the instrument, which is deposited. And 90 days after that date of deposit, there's entry into force. So how does that apply in terms of amendments and looking at the specificities of, in particular, the ban amendment? Just going back to the mandate we talked about at the start of the webinar. The general steps, as you can see here, would be that for an amendment to a convention to be adopted, there'd have to be agreement between the parties. Any party to the convention is entitled to participate in the discussions and negotiations of that possible amendment. And the amendment would bind those parties who formally express consent to be bound. There is the states becoming party to the convention after entry into force of an amendment, and they would be bound unless they express a different intention when they become a party. And then we have these specific steps which are set out in Article 17 of the Basel Convention in terms of the ban amendment. There are also similar provisions within the Stockholm and Rotterdam Conventions relating to amendments, and there are procedures set out in each of the conventions for amendments of the conventions themselves as opposed to amendments of the annexes. And again, the amendment would be binding on a new party unless it specifies otherwise when it becomes a party. So a flowchart demonstration of just how that would work for you. There's a communication, and this process, this diagram relates specifically to the process of the Basel Convention. The proposal to amend the convention is communicated to all parties through the Secretariat. There's then the meeting of the Conference of the Parties and negotiation, and if there's agreement, adoption of the amendment. After that date, after the adoption by the COP, the parties state whether they consent to be bound or not. There's a set period for doing so. And the party then deposits its instrument with the depository. And there again, you have the step of entry into force. There is a requirement under the Basel Convention that amendments of the convention would enter into force only after a certain threshold is met. So once that threshold is met, the amendment enters into force, and any parties who are new parties after entry into force are bound by the convention as amended, again with this proviso of expressing a different intention. There are similarities. Sorry, just to go back to that slide. One thing I would highlight in terms of the amendments to the convention is that this process would relate to the convention text itself. There are separate provisions in terms of the annexes to the convention, and there's a process in particular for Annex 9 amendments to the convention, which also have a process that goes through the open-ended working group. So there is an additional step for those amendments. There are similarities in the procedures applicable to the conventions and becoming a party to the conventions, but differences do exist in the procedures, particularly as they relate to amendments. And the instruments that would be used in terms of expressing consent to be bound by an amendment to the convention or to the convention itself would be similar. The Secretariat is available to provide those documents to interested states and parties. But there are also differences, particularly between, for example, the ban amendment to the Basel Convention and amendments to the annexes of the Stockholm Convention. We would highlight, just as a last note, that it's the prerogative of the party concerned to decide whether or not it wants to be bound by an amendment to a treaty. And the depository, who's guided by the Convention's provisions, has the authority to decide whether the requirements for entry into force are met. In the particular case of the ban amendment, the depository was provided with the text of the decisions that were adopted by the Conference of the Parties, and these will also be taken into account when looking at those requirements. So thank you very much, and we'll just leave you a few minutes now. I'll pass you back over to Dan.